All right, thank you everyone for coming. I know people are still grabbing food, but feel free to do that while we're going. So the Federalist Society for Law and Public Policy is a group of conservative and libertarians interested in the current state of the legal order. It's founded on the principles that the state exists to preserve our freedoms, the separation of government powers is central to our Constitution, and that it's emphatically the province and duty of the judiciary to say what the law is, not what it should be. The Society seeks to both promote awareness and understanding of these principles and to further the application through its activities. Today we have Professor Josh Blackman here from South Texas College of Law in Houston. He specializes in constitutional law and is interested in law and technology. Professor Blackman is the author of some critically acclaimed books, including Unprecedented, Unraveled, as well as being a member of the Forbes magazine 30 Under 30 for law and policy. He has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He's an adjunct scholar at the Cato Institute and is the founder and president of the Harlan Institute and Fantasy SCOTUS. He'll be giving about 35 minutes or so of commentary, after which Professor McManaman from our law school, who received her bachelor's from Yale and her JD from Cornell, who practiced litigation in Cleveland before coming to Delaware Law School, and who teaches civil procedures 1 and 2, as well as con law 2 and federal courts. Will give about 15 minutes of commentary. And she wanted me to mention that she once had somebody rate my professor on her as sassy. So
Sassy.
you guys know that.
Oh boy.
And I highly recommend taking every class you can with her while here. And then following that, Professor Blackman will again provide a response, and then Dean Smola will lead some question and answer at the very end. So without further ado, Professor Blackman.
Thank you.
Thank you.
Thank you so much. This is my first time at Widener and my first time speaking in Delaware. I've driven through. I've stopped on 95 but never actually gotten around, so it's good to be here. The topic today is focusing on the Supreme Court, but from a different angle. I'm less concerned today about the Supreme Court itself, but how people get onto the Supreme Court. And in particular, how do Supreme Court confirmations operate? And this talk is based on an article I wrote with Professor Randy Barnett at Georgetown a few years ago. And we discuss various ways to improve the Supreme Court confirmation hearing. So let's start with an event I'm sure you're all familiar with, Justice Scalia's passing. He passed away in February 2016. After that, President Obama nominated Merrick Garland to fill the seat of Justice Scalia. At the time, President Obama was quite candid. He faulted both Republicans and Democrats alike for their positions on judges. He said, quote, "There's been politics involved, nominations in the past, on both sides." He's right. Over the past 3 decades, presidents and senators from both parties have ratcheted up the tensions over Supreme Court nominations. And the linchpin of that conflict has become a meaningless ritual, the confirmation hearing. But not for the reason you may think. The conventional wisdom is that in their current form, confirmation hearings serve no meaningful purpose. That's because that the nominees refuse to answer any questions that could jeopardize their prospects. Instead, the theory goes, when asked a controversial question, the nominee equivocates and obfuscates. These nominees have rigorous training, so-called murder boards, that prepare them to answer questions by shedding as little light as humanly possible on how they'll behave if confirmed. The end result is not very impressive. About 2 decades ago, a legal scholar described it this way. She wrote, quote, "When the Senate ceases to engage nominees in meaningful discussion of legal issues, the confirmation process takes on an air of vacuity and farce, and the Senate becomes incapable of either properly evaluating nominees or properly educating the public." Who was that scholar? You know her, Her name's Elena Kagan. And perhaps because she was so astutely aware of this phenomenon, when she was nominated to the Supreme Court, she did exactly what she criticized others for doing. She didn't answer any meaningful questions. Now, why are we at this place where judges are so afraid or unwilling to answer substantive questions? Some of this goes back to the nomination of a guy named Robert Bork to the Supreme Court. Now, I'm guessing they probably weren't alive during the Bork hearings, at least most of you weren't. But in 1987, President Reagan nominated Robert Bork to replace Lewis Powell. Lewis Powell was the moderate, the swing vote. And Robert Bork was a very conservative judge. His nomination went down for a lot of reasons, But one of the main reasons it went down was because he was actually candid. He answered a lot of their questions. And he gave people answers to the questions that they didn't quite like about abortion, about civil rights laws, and other topics. And there's a reason why. When most of the senators are asking these sorts of questions, they're not really interested in the legal reasoning. They care about the result. Do you think Roe is good or bad? Do you think the Second Amendment and Heller are good or bad? Do you think Citizens United is good or bad? Right? They all focus on sort of results rather than the actual reasoning. And the nominees now know they can't give an answer on what the results are going to be, so they just sort of back off. Randy and I think that there's a better way of handling these hearings. Rather than trying to pinpoint a nominee on what result would they reach, which they're not going to answer, they're not going to give an answer, we should instead focus on their methodology, on their approach, on how they understand cases, and more particularly, not how they like a case, but how they understand a clause of the Constitution. That is a far more meaningful approach. And it prevents nominees from doing this little dance, this little show and dance, where they sort of dodge questions. You can pin them down. So that's what I want to talk about today. How can senators shift the focus of these hearings to get at what a justice thinks about the Constitution? And I will close my remarks a little bit later with some observations from the most recent hearing, which was that of Justice Brett Kavanaugh. Okay. So let's start with Bork, right? Robert Bork was a former law professor. He served as a Solicitor General and had a lot of other government positions. During his hearing, he was very candid about how he would approach certain kinds of issues. That backfired significantly, and his nomination went down. After the Bork nomination went down, President Reagan picks the second person for this seat, a guy named Doug Ginsburg. Now, why have you never heard of Justice Doug Ginsburg? You've heard of Ruth Bader Ginsburg. You've probably never heard of Doug Ginsburg. The reason why is he got in trouble. It turns out, this is funny, he smoked some pot with students. Now, today that would give him like a faculty award, right, for best teacher, right? But back in the day, that actually disqualified him, just say no, right? And that actually knocked him out of the running, that this report that he actually smoked some dope with students, that knocked him out. Okay. The third nominee for the seat was actually Justice Kennedy, his name I'm certain you know. And Justice Kennedy was fairly transparent about his views. He talked about the importance of privacy, about the evolution of rights. He didn't give the sorts of rigid answers Bork gave. And that seemed to work a little bit better. But since this Bork fiasco, the nominees have three moves. And you'll watch the hearings, you'll see these three moves over and over again. Okay, move number one. You profess fealty, you profess loyalty to the text of the Constitution and its original meaning, but you also say, I follow the general principles underlying the text. So you see the pivot, right? You start with the text, basically then you go back to principles, right? Not always easy to square. The second move is you profess fealty to stare decisis, right? The idea that you have to follow legal precedents. especially when those precedents aren't necessarily consistent with the text of the Constitution. So they always start with text, but then they back off pretty quickly. And then the third move. The third move is when they're asked to apply any of the precedents to current cases, they say, I cannot answer. They decline to answer. Why? Well, I think there's a practical reason why. If a judge indicates in advance how he'll rule in a case, a judge will probably have to recuse. Right? When you go to a court, you don't want a judge who's already told you how he's going to rule in the case. It's not fair. So the judges are not going to answer, will you overturn this case? Will you overturn that case? They're just not going to answer. So as a result, these hearings are kind of like Seinfeld. They're hearings about nothing. Nothing of actual substance goes on. So here's what Randy and I propose. Instead of talking about what they think about a case, senators should ask them, what do you think about specific clauses of the Constitution? For example, does the original meaning of the Second Amendment protect an individual right to arms? What was the original meaning of the Privileges or Immunities Clause of the 14th Amendment? Did the 14th Amendment incorporate the Bill of Rights, and if so, how? Does a necessary and proper clause delegate authority to Congress to do whatever is convenient? Does the 9th Amendment protect judicially enforceable and enumerated rights, etc.? Now, what's going to happen is the nominee will start answering, oh, in this case, the court held this, and in that case, the court held that. But that's when you stop them. Say, no, I'm not interested in cases. Because once you go to cases, you're going to duck my questions. I want to know what you think. What are the primary sources? What are the historical methods you'd rely upon, right? Is text a factor? How do you go beyond text? These are far more pressing questions than will you agree with this precedent? Will you go with that precedent, right? They're not going to get anything of meaning. And it'll force the nominee out of this sort of script they can repeat over and over again. Okay? So now let's talk about the most recent confirmation hearing, that of Justice Brett Kavanaugh. He says things like, my judicial philosophy is straightforward. A judge must be independent. A judge must interpret the law and not make the law. A judge must interpret statutes as written. A judge must interpret the Constitution as written. Okay, meaningless, right? Utterly vacant. Sotomayor said the exact same thing, right? These statements don't give you anything of any merit. Now, one senator, Senator Lee, actually tried to pin down Kavanaugh, right, a little bit. He said, well, you know, would you consider yourself an originalist? And Kavanaugh sort of hemmed and hawed and danced. He didn't want to answer the question. He got there eventually. But eventually, Kavanaugh was pinned down, and he said, that's correct. I'll be described as an originalist. That is far more helpful than these sort of just vacant statements of, I follow the Constitution as written. You all do. They always do. It doesn't really give you too much. All right. Now I want to shift a bit. I've described why the current nominations and the current process are pretty bad. How can they be improved? So I have one major suggestion that will never go into effect. I think it's a good one. The senators should not be asking the questions. Okay, let me make this point bluntly. When a senator today asks a question, they're not really interested in the response. They're making a point for TV. And I'll make this point even blunter. They want a viral clip, right? They want a 45 to 1 minute clip on Twitter to go viral. They're trying to jab the nominee to get him to admit something bad and then zing him and get 1,000 retweets overnight, right? That's what they're looking for. Okay, it's wonderful for politics, but meaningless for actual discussion. So my first suggestion, and this again is never going to happen, is that the Senate should hire people, professionals, to ask the questions. You may have actually seen this during the Kavanaugh hearing round 2, where they had a special prosecutor ask Kavanaugh and Dr. Ford specific questions. Now, I think the way that it's set up was terrible. 5 minutes, 5 minutes. That was very disruptive. But you at least had a person who was trying to ask meaningful questions and not make political points. So who do they hire? I don't know, law professors maybe, right? Practicing attorneys? A public defender? I think that'd be a good way. Have a district attorney, right? Have different lawyers from different walks of life who know about different areas ask questions. Have a corporate lawyer, have a family lawyer, right? Give someone a chance to actually meaningfully inquire into the person's approach rather than having the exact same senators ask the same stupid questions over and over again. By the way, they're not all there for the entire hearing, right? They only come in for their part. So very often they repeat stuff that had been asked before because they're just not paying attention. So I think that the Senate should hire professionals to ask these sorts of questions. And each side gets, say, an hour. And it's 1 hour straight, not 5 minutes, 5 minutes, 5 minutes. That just is not effective. Give each side 1 hour and let them basically conduct a deposition, right? A cross-examination. You can lead and ask all the tough questions. And then you get the person on the record. That would be a lot more meaningful. It would reduce the temperature, which I think is important. It would make it less political. I don't want these hearings to be so political. Second, I think you get more insights into the judge's philosophy, right? You're more likely to actually figure out how they approach questions rather than racing the clock. And third, I think it'd be educational, right? The people, the United States, watch these hearings, right? How many of you watched the Kavanaugh hearings this summer? Okay, almost every hand went up, right? Maybe you learned something, maybe you didn't, I don't know. But if you actually had a substantive discussion where you had a back and forth, a human dialogue, people would learn something. And I think that's a civic virtue to teach people about the rule of law during these hearings, right? Once they get in the court, never see them ever again. They're always, no cameras. But here, they're in the limelight. Okay, so that's my first proposal, which will never go into effect. My second proposal is a little bit more audacious, and it definitely won't go into effect, but I think it's good. The Constitution says that the President shall nominate, and the Senate provides advice and consent, right? There are two things. There's advice, and there's consent. Under the current frame, the Senate only does half of that. They consent. They either vote up or down, yay or nay. Where's the advice, right? Where's the advice? So here's my proposal. The Senate provides its advice before the nomination is made. Huh? Josh, what are you talking about? Follow me. We all know that there are 9 justices. And at any given point in time, one or more may retire, may pass away, may step down, who knows? We know who they are. And we also know that the government has what's called the short list, right? What's a short list? It's a list of possible nominees who could be used to fill a vacancy on the court. Now, President Trump did something unique 2 years ago. Or actually 3 years ago now. He published his list, right? Usually the president keeps the list quiet, close to his vest. But President Trump candidate Trump published his list. I think that was actually a good idea. I think he probably won the election in part because of that list. Because people could be confident that he would appoint someone they like. But the president's not the only one who can have a list. Why can't the Senate make its own short list? And here's how it would work. Again, this will never happen because it's very effective and very nice, but here's how it would happen. The majority party proposes a list of names. The minority party proposes a list of names. It could be 10 names and 8 names, 5 names and 3 names, whatever the number is. I don't really care about the number. They say, if there's a vacancy, here are the 10 people we think should be considered for the Supreme Court. And then the Senate takes a vote, non-binding, but they take a vote on each of the 10 nominees. And maybe one person gets 80 votes, so one person gets 40 votes, one person gets 60 votes, one person gets 20 votes, right? But you take a series of non-binding votes in advance of the nomination, right? You wait till the vacancy arises. President usually takes about a month to make the pick. Senate takes a number of votes. Then what does that do to the president? Well, he says, look, we have these 10 people. Person A got 20 votes, person B got 30 votes, person C got 40 votes, and person A got 80 votes. Wow. Maybe I should pick the person who got 80 votes, right? If there was someone that actually got that much of a consensus, maybe that's impossible, I don't know. That maybe I should pick that person. And then if the president picks the person who got the 80 votes, he or she will be basically confirmed of a successful confirmation hearing because you already have buy-in, right? You had advice before consent. And I think that would do a lot of good work to change the climate of these hearings, make them less political, make them less partisan, and dial back the temperature. Now, why will this never happen? Right? I'll give you a very easy reason, right? Senators don't like taking tough votes. Most people in government get there by avoiding controversy. The idea that the senators would voluntarily vote on a controversial nominee that will never come to the actual Senate floor is a delusion. It's not going to happen. But this approach may work better for the lower courts, right? And it kind of already does. Often home state senators will recommend someone for a nomination. But I think for a Supreme Court vote in particular, this could do a lot of good work. But it won't. So I've given a couple suggestions of how Senate confirmation hearings for the court could be improved. The first one about talking about clauses of the Constitution, I think a few senators picked up, Senator Lee and others are starting to use our idea. Great. Second idea, hire professional lawyers to do the questioning. Not going to happen. The third idea, giving advice before consent. Not going to happen. Not going to happen. So where does that leave us? We're in a pretty bad spot. I'm actually very pessimistic about this process going forward. And I'm not here to blame anyone. Maybe you can blame, but I only want to talk about what happens going forward. When Justice Scalia passed away, Judge Garland was nominated. Republicans took no action on his nomination. That was a significant move. A significant move. Had Hillary Clinton won the election, she probably would have put Garland in the Supreme Court, or maybe someone else. I don't know. We can never know for certain. But instead, Trump won the election. And he put on Neil Gorsuch. And then last June, Justice Kennedy retired. And Justice Kavanaugh was confirmed on a very close vote after two very contentious rounds of hearings. What about the next nomination, right? Both the Scalia and the Kennedy seat were a Republican-appointed judge being replaced by a Republican-appointed judge. The next one could materially shift the balance of the court if it's Justice Ginsburg or otherwise. At this point, the filibuster is gone, so a simple majority vote works. And at the present moment, the Senate's controlled by the Republicans. But what if, just bear with me, what if in 2020, the election coming up soon, the Democrats take the Senate and the President Trump wins re-election? And then a vacancy arises. I am willing to bet money, and you should not bet against me this one, that that seat stays open for 4 years. That throughout the duration of the Trump presidency, that seat stays open. Now, the Democrats say, go put Merrick Garland in the Supreme Court. And the Republicans, Trump will say, no way, put my guy. And I think the seat will simply stay open. I wrote about this years ago before Scalia even passed away. But I think we're looking at the distinct possibility that we have extended periods on the Supreme Court with vacancies, down to 8 justices, maybe down to 7, 6, I don't know. As long as you have divided government, I don't think we will see the Supreme Court justice confirmed. Only when you have unified government, that is the Senate and the presidency are in the same hands. And this problem, I don't think, is limited to the Supreme Court. I think it will bleed down to the lower courts. During the Obama presidency, Republicans in the Senate blocked a lot of, not all, but a lot of President Obama's nominees to the federal courts. Now, President Trump has control of the Senate, and almost all of his nominees are getting through. But again, if the Democrats take the Senate and President Trump keeps the White House, which, if you look at the map, it's totally possible, I think the Democrats will basically grind to a halt any nominees to the lower courts that are not approved by blue state senators. And then at that point, does the president just let the courts stay empty, or does he start making compromise? I think it's a hard question, because maybe he'll say, well, maybe we'll win the Senate back in 2 years and we'll just pack the courts then. there's a reason I'm not optimistic, because I think this is a very pernicious and downward spiral. Each side just one-ups the next one. And again, I think trying to trace this back to a single root cause is impossible and largely unhelpful, because we are where we are. I offer these proposals, I think, to try to mitigate and to lower the temperature, but I'm not confident. And ultimately, this, I think, results in a higher degree of politicization of the courts than we already are. I don't know how to fix this. And I think a lot of the people on both sides of the aisle are more concerned with getting their guys in the court than actually addressing these bigger pictures. So I leave you with a fairly pessimistic note, not why you probably came here today, but I do offer these suggestions to perhaps improve the climate. I will stop here, turn over to my good friend, and we'll take some of your questions later. Thank you so much.
Well, this commentary is going to be kind of tough in that I agree with a heck of a lot of what Professor Blackman said. I will say this. I think that my glass is half full, however. I think that this period of extreme division will wear itself out like a fever, that the fever is going to break. This is not the first time we have had this incredible headbutting over court appointees. I'd like to refer you back to the post-Civil War era. Initially, and I know you've probably heard talk about should we add seats to the court. 9 is not a magic number. Initially, there was a seat per circuit. The justices rode circuit, and so you were each assigned one, and as more circuits were added, more justices were added. And that continued till about the Civil War period when it went up to 10. But unfortunately, President Lincoln was assassinated, President Johnson took over and was at loggerheads with the Senate. And in order to prevent him from having any appointee, number one, they reduced the court from 10 to 9, where it's remained ever since with a little hoopla under FDR when there was talk about changing it. And they just wouldn't appoint, they would not allow appointment for one of the empty seats. So this has happened before, we got through it. I'm hopeful that we'll get through it again. I do agree with the basic premise of Professor Blackman's talk, which is that Senate confirmation hearings are a waste of time. Nobody says anything. He's absolutely right that that our current period of this kind of battling, of dissembling, goes to just Judge Bork's failed confirmation, and everybody just says absolutely nothing. I'm not sure of his solution. Having professionals sounds very interesting, and in fact, they sort of do it now. The senators don't write their own questions, right? They have other people who write their questions and their staffers, so that they would just, I guess your proposal would have them make a more prominent role. I think that's very interesting. The one area that I disagree with or question is an area that he really filled out much more in his article than he did in his talk, and that's the changing of the question to clauses, not cases. As explained in his article, the purpose really is, and you'll notice he talked about asking questions about what was the original meaning of the Second Amendment, or what was the original meaning of the Privileges and Immunities Clause, etc. The goal is to shift from those who would give a more expansive view of the Constitution to those who would have a more restrictive view of the Constitution. And I want to remind you of what Mr. Schnapp said at the beginning about the Federalist Society, and the purpose is to foster the view that the court interprets the law as it is, not as it should be. That implies that there is a correct view of the law, and that is, of course, the position taken by originalists. I'd like to talk a bit about putting too many of one point of view on the court. First of all, many studies have been done that show that decision-making is better just as actual measurable qualifications, if you've got a diverse group making it. And so to me, I think allowing to have justices from all sorts of perspectives makes a better Supreme Court than a court that looks at it from one point of view. I just want to talk about a few men who have really been great justices and talk about how their approaches are totally different. First one I'm going to mention is Hugo Black, right? Constitution in his pants pocket, strict constructionalist, gave life to the Bill of Rights, told President Truman, you can't do that, but it was all based on what's in the text. Compare him with Felix Frankfurter. On the bench at the same time, totally different. His whole philosophy was the federal courts are doing too much, they are too aggressive, we need to pull back on the judiciary vis-a-vis Congress, vis-a-vis the states. Justice Brennan, the opposite. Open the doors wide. Let justice be done. Let's change standing requirements or subject matter jurisdiction requirements to let more and more people into the courthouse so that we can listen to them and dispense justice. Justice Stevens, very, very deferential, also restrained, very deferential to Congress, saw it as a co-equal branch and one that should be respected and deferred to. And of course, those of you who know me, who've had my classes, know I can't have this list be complete without David Souter on it. Very, very traditional. He's been given a total misnomer by the punditry who call him the dean of the liberal wing. He's one of the most conservative justices ever to have served on the Supreme Court. And what he did was start with the text. You're not going to be up at the Supreme Court if the text is clear and the answer is obvious, right? That you don't spend your money on litigation when it's that way. So he starts with the text, but then looks at what did we do and what did England do that brought over that we got it? What did the framers say? What is the precedent? And brings it up to today. I've never seen an agenda-driven opinion from him. So anyway, so these men all had a totally different approaches to the answer, and I think the court was stronger for having these different voices. Second, the originalism is a new theory of constitutional interpretation, dating basically to the 1980s. There have only been 4 justices who espoused it, who sat on the court: Justice Scalia, of course, Justice Thomas, Justice Gorsuch, and Justice Kavanaugh. It was started by groundbreakers like Professor Bork, Professor Scalia, and of course the Federalist Society. Scalia did much to foster that, right? And he was aided by Edwin Meese, who was Attorney General to Ronald Reagan, who set up seminars and conferences, had training programs for White House staffers, congressional staffers, to promote and foster the growth of originalism. But I don't see that. I see that as a claim to have a seat at the table. I don't see it as a claim to have all of the seats at the table. In addition, it can be problematic. As I mentioned, it's a discipline, an approach to the Constitution that dates from the 1980s. But there are a couple of instances in which the Supreme Court did address original intent. What did the people of the time think the clause meant, the words meant? One in which the court accepted that argument, and one in which the court said, no, don't think we're going there. The first case is Dred Scott. Was an actual case about civil procedure. Was there diversity of citizenship? And you all remember, I know from your first year course, that citizenship for diversity purposes includes United States citizenship. So the question was, could this enslaved person claim citizenship under the United States Constitution? And what the court said was, you know, we may have progressed in our view of these people, but you know what? At the time of the framing, the dominant race did not consider them to be equal. They were 3/5 of a person in the Constitution, and there's all sorts of other evidence that the court masses to say these people are not part of our body politic. And the court says, thus, we may have changed our view, we may have a better view of this situation, but the people at the time of the framing did not consider these people to be United States citizens, and so therefore, they cannot be United States citizenship. There is no diversity. A second case in which the court was asked to think about what was going on at the time of the framing, what was the view of the citizenry, is Brown versus Board of Education. The 14th Amendment Equal Protection Clause was drafted by the same Congress that then went on and segregated the District of Columbia schools. So if the people at the time that the Equal Protection Clause went into place were cool with segregated schooling, how could the plaintiff make hay in the Brown versus Board of Ed? And of course, the court said, we're not going to go that way, we're going to go in a completely different way. And finally, the use of originalism using legal history has the same weakness that history does, right? Looking at history from our vantage point here in the 21st century, we can't always tell exactly what was meant, so it's tough to come to a true answer. It can be very murky, and trying to do so can lead us down the wrong path. And that was forcefully shown by the two opinions, the two dueling originalist opinions in DC versus Heller. Justice Scalia, writing for the court, went through contemporary dictionaries, the English Bill of Rights, what states were doing, and came to the conclusion that the Second Amendment included a right of self-defense, and therefore the District of Columbia law, which did not allow you to have bullets in your gun in the home, was unconstitutional because it hampered the right of self-defense. Justice Stevens wrote a completely different opinion, citing almost all the same sources, the English Bill of Rights, the contemporary dictionaries, local state practice, and he came to the conclusion that the Second Amendment was in response to a clause in Article 1, Section 8, which said that Congress gets to arm the militia. And there was a fear that that meant Congress could disarm the militia. And thus the militia language in the Second Amendment is crucial and shows that they were trying to do that. Who's right? Right? They're both very forceful, they're both very compelling, and therefore it can lead to difficulties. So, as I said, most of what Professor Blackman said I think is very interesting. I think it's a topic we need to look at. It really is very exasperating to watch these hearings where people say absolutely nothing. But as I said, I wouldn't go for the clauses, not cases, for the reasons that I've just explained. Thanks.
Thank you. Thank you. You know, I like when people agree with me, so I'll take it. I'll just focus on one of the last parts. A common tactic at recent confirmation hearings is for a senator to ask a nominee, do you think Brown versus Board of Education was correctly decided? Now, it's a bit of a trap, right? I'll explain the trap, right? They say, yes, I think Brown was correctly decided. Okay, what about Roe v. Wade, right? That's the... It's such an obvious trap. So the nominees sort of twist and turn to avoid answering the Brown question, so as to avoid answering the Roe v. Wade question. And it's very painful, and there are a lot of viral clips about it. I'm not convinced that a nominee has to avoid that question. In fact, I think an originalist can say that Brown was correctly decided. It's a very important article by Professor Michael McConnell, written in the 90s, which discusses why the Privileges or Immunities Clause and not the Equal Protection Clause was the correct basis for school desegregation. I find that argument quite persuasive. You can Google it, but I think there's actually a pretty good argument that by the time the 14th Amendment was ratified, education as citizenship, as a privilege of citizenship, and the 14th Amendment protects it. So there's arguments there. But I think a far more important question for a senator to ask is not, do you think Brown or Roe is corrected? The question is, will you extend this precedent? If you are a lower court judge, you can't ignore a Supreme Court precedent any more than you can decide a case by flipping a coin. You can't do it. So they say, will you follow Roe? Of course I'll follow Roe. I'll follow Casey, whatever else you got. But the question is, will you extend it, right? Let's say the Supreme Court upholds an abortion ban at, I don't know, 30 weeks. I'm just making up a number. And then a state says we'll pass a ban at 29 weeks. Just making a number up. Will they extend it? They'll say, no, we will limit Roe to its facts as we think it's wrong. That would be a lot more meaningful. And I have a piece coming out about this at some point soon about originalism in the lower courts, which teases this issue. But I'll stop talking. I want to have lots of times for Q&A, and Dean Smolla has urged me to hear from you, so I welcome your questions. So thank you all so much.
Thanks. And why don't we just invite people who have questions, concerns, or observations to engage our panel?
Come on.
Not all at once.
Yeah.
Yes, ma'am.
I have a question regarding the appointment process and how, we have this sort of ongoing issue with presidents packing the court while they're presidents, so they can get their ideologies heard and that sort of thing. We see that with President Trump, to a lesser extent with Obama. But what do you think if we eliminated the lifetime appointment of Supreme Court justices?
Yeah.
And instead instituted something closer to like a cyclic period where they're on the court for, say, 16 years, which would allow presidents to sort of institute new justices throughout time.
Okay, very good. So there are several proposals outside of expanding the number of courts, or sorry, expanding the number of judges. I think expanding the number of judges is stupid, right? It's just going to lead to a race to the bottom. Oh, you have 11, I'll do 13, I'll do 15. This doesn't end well, right? If the problem is judges are making decisions that are not good, adding more judges will not fix that problem. It'll just make it worse, right? 'Cause there'll be more judges make more bad decisions. So you mentioned one proposal, which is term limits. I think that's a good idea. I think every country in the world that has a judicial system has some form of term limits or a mandatory retirement age. I know you can frame it in different ways. I do think that would require a constitutional amendment, and it's one I think I would back. Now, some scholars suggest that you don't need an amendment to the Constitution. Instead, you do something with panels. What do you mean? Well, if you go to the Third Circuit, right, they usually sit in panels of 3. But they're what, maybe 12 or 14 judges at a given time, right? So the idea is, well, we can just add more justices, but only draw 3 at a given time for a given case, and it's a random draw. So when you argue a case to the Supreme Court, you don't know which 3 you're going to get. And then if you want, you can appeal from the mini Supreme Court to the Super Supreme Court of all 16 of them. I don't think that works, right? The Constitution says a Supreme Court, one Supreme Court, not panels that can hear it in different ways. I think you're basically inserting another layer into the appellate review. Don't ask me at Marbury, I think this is bad, but I don't think you can make the Supreme Court review its own decision. It's a very weird hierarchy. So one option is the panels. I don't think that works. Another option, which I kind of like, is you could actually have lower court judges potentially sit in the Supreme Court on rotation, right? That way you don't know who the 9 are at any given point. They could actually basically cycle up lower court judges. Now again, I think that would probably require an amendment to the Constitution. Again, I like the Constitution. Hugo Black had it in his pocket, I have it in my breast pocket, right? I carry it everywhere. Ain't perfect. I think there are ways to improve it, but I think you would probably need an amendment to make meaningful changes. But very good question. Thank you so much. Yeah, in the back in the corner? Either one, yeah.
Hi, thank you. First, thanks for both of your talks. That was great. I guess I got a few things I'm thinking about. Well, first, there's no disagreement that the hearings are kind of meaningless and everybody knows that. But I'm not sure that's really the problem that we're talking about. Because we know how Gorsuch is likely to go, and we know how Merrick Garland is, and that's really the underlying political battle here. And it's not so much what happens in the hearings. Now, one thing I'll push back, as Professor McManus did on the originalism, is the whole conundrum of constitutional laws. Why do we have this little tiny cabal of people override democratically elected laws in a democracy? What gives them this right to do that? There's a tension there. And I think with originalism, there's the way to resolve the tension is, they're not just doing what they think is right. They're just doing the original intent, the framers' intent, the original public meeting, as if there was this Mount Sinai moment, and God told them the right answer, and they just applied it. And I think that, how many classes have the students had here where you do Fourth Amendment on reasonable searches and seizures? There's an entire library to figure out what that means. First and free speech, an entire library, equal protection, due process. I mean, the kind of notion that, we're just going to find the original meaning because we're not imposing our own will is just this kind of myth. And it works if you've got a conservative orientation because there's not a lot of sympathy. History's probably not going to support gay rights. and women's rights and contraceptive rights and things like that. I think the bigger question is, judges are influenced by the values, and who's on the court makes a difference. And what do you do in a situation like Merrick Garland where you've got split government? And I think the big problem we have is the Constitution was structured on a philosophy that will be followed in good faith by participants in the political process. And when you've got split government, the answer to that is people on different parties have to come together, and they've got to find a candidate that is going to be as tolerable as possible so that Obama could appoint him and Republicans can join him and get that person through. That's what the process is. And when we moved in this direction of this hardball politics of we're going to filibuster forever, the filibuster actually was a good thing for bringing people together. But this notion is we're going to wait 4 years and not appoint someone. We're not going to be, everything's going to be, burn and destroy instead of cooperate. That's where I think the problem is. And the Constitution was framed on the assumption that the political actors will cooperate and compromise. That's what the Constitution is a compromise.
Well, thank you. There's a lot there. Maybe you can invite me next year to do a debate on originalism, which I'd be happy to do. But let me address this as a general point. There are a lot of rights and cases of the Supreme Court that are fairly modern, and he mentioned a few of them. And he says, well, what happens if originalism doesn't support those cases? Then maybe the answer is the democratic process takes care of it. Right? In other words, you don't have to adopt a constitutional theory, or you don't have to oppose a theory if it leads to results you like or dislike. Very often, my own theory of the Constitution leads to results that I don't particularly care for, but I follow it in any event. I'm pretty libertarian. I'm actually not very socially conservative in most regards, but I think a lot of the decisions of the court are very hard to justify. But thank you. Let's do originalism maybe next year. I think there's a hand up there somewhere. Yeah.
Right here. So I really like Professor McMahon's comment on the diversity of the court and your justification for it. Could you speak a little bit about your perspective of how you think diversity might help or hinder the court?
Okay, so the question was there were different perspectives, different ways of approaching the Constitution. I'll put my cards on the table. I'm an originalist, card carrying, and I think some methods are better than others. The Brennan approach of let's just do whatever the hell we want. We got 5 votes, doesn't really matter. That doesn't work for me. So if you have that as one of the different perspectives, it doesn't add much. I think Souter is an example. I think he's a little bit underrated, and I agree with Professor McMahon on that one. He's an old school conservative. Maybe Frankfurter is a good model. I don't quite. Harlan too. I think it's a good model. He's very unique, and I think he's not well understood. I think people misjudge him. I think he often voted with the liberal wing of the court, but I think he did so for more traditional stare decisis reasons. I mean, one of his most famous opinions was Planned Parenthood versus Casey, right? This was the major opinion from across the river in Pennsylvania about upholding their abortion laws. And there were 5 votes to overturn Roe. And Souter, Kennedy, and O'Connor formed this little troika where they wrote this joint opinion which upheld Roe kind of, but not really, and then stood by part of it, but other parts they got rid of, and it's complicated. But the opinion had a very detailed discussion of stare decisis. And Souter basically wrote that. That was his contribution. So Souter's an interesting guy, and I don't begrudge him at all. I think he had his own perspective. So some perspectives I'm okay with, other perspectives I think we can maybe do without. But thank you for the question.
Can I just
Please.
add that Brennan was a very rules-oriented kind of guy, and so your description of him was somewhat inaccurate.
Okay. Yes.
So when I hear I'm an originalist, correct? To me, it just discounts the Warren Court and the more progressive bench. So I want to know, where is the practice to swing the pendulum to an evolving standard of decency. Because if I think of originalism, I'm not even identified as a full human being, correct? So how does someone with that ideology, i.e. me, swing the pendulum forward?
Okay, well, thank you for the question. So the first part about originalism is we have 2 points in time. We have 2 foundings, right? You have the founding in 1787, which included the Three-Fifths Compromise you alluded to. And then you have the second founding in 1868 with the ratification of the 14th Amendment, which eradicated that provision of the Constitution. All persons born in the United States are citizens. So originalists look at both periods. So I don't think there's a tension there. Then you have precedents that I think were quite wrong. Things like Plessy and the Civil Rights case, I think, were actually mistakes, and they were not consistent with the original meaning. I think the Supreme Court deviated. But the second part of your question about the Warren Court and sort of the evolving decency, I don't have a problem with society maturing and developing. But the question is, what are the means by which it happens? Does it happen through the political process, or does it happen through the judicial process? I think having a fixed constitution means that a lot of changes have to happen through the political process. And we've had some success, and in other places the courts have intervened. I will note that some of the Warren Court precedents, which didn't purport to be originalist, actually had originalism basis. I mean, perhaps one of the greatest defender of criminal rights in the Supreme Court was Justice Scalia. He wrote a number of opinions in the Confrontation Clause, in the Fourth Amendment context, that were quite originalist and very pro-defendant. I mentioned Brown a moment earlier. I think that's a decision that can be consistent with the Privileges or Immunities Clause. So it's a bit of a mixed bag, right? You may not get everything you want, but I think there's more there than you might otherwise think. But thank you for the question.
So I think we have 5 minutes. I'm just going to ask one
Please.
question myself, and I'd be interested to hear from both of you. I guess it's a 2-part question. First is an historic question. Can you think of senators who have taken the position that when there's a vacancy, a president is entitled to try to move the court as she or he wants? And I will not cast my vote based on whether I like or don't like that direction. I'll limit my scrutiny to professional qualifications. Has there ever been anybody that has taken that position? So I will vote for Robert Bork, even though I'm opposed to his views, because he's obviously one of the greatest lawyers in modern history. Argued 40 cases in the Supreme Court, taught at Yale for 20 years. How can you argue with his intellectual capacity? And then the second question is that the wrong way to comport oneself as a senator? Is that improper? Or is it in fact the preferable way to comport oneself? So I'd be interested in where each of you think.
It's a very good question. If you watch the Kavanaugh hearings, at one point, Senator Lindsey Graham, who's in the news a lot now, he's from South Carolina, and he made a point over and over again that he voted for Justice Kagan and Sotomayor, even though he disagreed with them, because he adopted the perspective of the dean. They were qualified, right? Sotomayor has been a judge for 20-something years. Kagan, a little bit less qualified, but she at least been the Solicitor General. She had been the dean.
Not too shabby.
Yeah, not too much. She never tried a case, though. She didn't have much actual lawyering experience. But I think she was qualified. She met the threshold. She crossed the threshold. And Graham made a point of saying over and over again. He said to Kavanaugh, "You tell Sonia and Elena that Lindsay said hi, right? Because you want to make a point. I'm going to vote for you, regardless of your qualifications." But look, a lot of Republicans voted against Sotomayor and Kagan. And then when the Gorsuch nominee came up, look, Gorsuch had been a federal judge for a decade. He was qualified. And his vote was it 53 votes he got? 40-something voted against him. It was a tight vote. And I think people perhaps were still bitter about the Garland situation. That might have been part of it. But I would like to go back to the day when the nominees are voted on based on their qualifications. I don't think we're going back to that period. I'll give you an example. Justice White, right? Whizzer White. You may not even know him, but he was a big deal. He was a professional football player, went to Yale Law School, went back to play football. I mean, this guy was a monster. His hearing was basically them all asking questions about football, right? And most of these senators were confirmed on voice votes. That just is, there was no actual recorded votes. Like, yeah, whatever, he's fine. I don't think we're going back to those days.
Well, that's my glass half full. I think we might.
I love, she's such an optimist. I love it.
Just call me Pollyanna. I mean, I can't name any senators, but I think we've had decades and decades in the history of this country where the senators just voted for the nominee as long as it was somebody who had the right backing, didn't care about the politics. As to the question, which is better or which is right, I don't think there's an answer to that. I mean, I think it's an eminently political process because you've got the Senate and the president involved. You go back to George Washington and never appointed anyone that wasn't from his political party. So I just am hopeful of a time when it's not so fractured as it is.
And I suppose the psychology changes depending on whether the vacancy is direction changing. And so if a conservative justice retires and a conservative person is put in, it's a replacement vote. Gorsuch was sort of like that.
Yeah.
It still was contentious, but it's that way. But when it appears that the balance is at stake, that makes a difference. Well, please join me in thanking our guests.
Thank you. Thank you. Thank you so much. Oops. Thank you, Dean. I appreciate it. Thank you, sir.
All day. It was great.
Thank you, sir. Thank you. Thanks, Zach.
Good?
Thank you so much.